Mr. Kinney, how do you know Mark Poe?
What do you mean by no?
When did you first meet Mark Poe?
I met Mark Poe by telephone at some point last summer.
And did he reach out to you, or you reach out to him?
I don't recall.
You don't remember if it was just like a phone call out of the blue, or if it was someone that you found and contacted?
No, I don't remember.
You don't remember? What was that phone call about?
What was it? What was discussed on the phone call?
Correct.
I'm going to object on the work product privilege. Mr. Kinney was communicating with Mr. Poe as an attorney working on our case, and communications gathered their attorney-client privilege and work product.
Oh, so is Mark Poe an attorney working on your case?
I'm an attorney.
I'm going to instruct the witness again to not answer that on the grounds that seeks attorney-client communications and work product privilege information.
I was asking you, Mr. Mort.
I'm not a deponent here.
Yeah, but you just made an objection that based on the fact that Mark Poe is an attorney, and I just wanted an attorney working on this case. So I just want to confirm with you that Mark Poe is an attorney working on this case.
I stand on our objection.
You're not going to tell me?
Correct.
But your objection is that the first phone call between Mark Poe and Robert Kinney was work product?
That's not what I said. My objection's on the record.
What is it? We're meeting.
You can have the court reporter read it back.
I'd like to ask you again what your objection is, because you said, I know you said for a fact that it was work product. Now it sounds like it's not work product.
My objection's on the record. You can have the court reporter read it back to you.
So you won't tell me again?
I've stated my objection. I'm not going to rephrase my objection.
Robert,
sounds like you don't like my objection. You want to have me read.
I don't like anything.
I'm not going to recast.
Ray, I don't like anything about you. Mr. Kinney, do you is Mark Poe an attorney who has been engaged to work for you on this case?
No.
Okay. So what was the substance of that first conversation?
I'm going to object grounds of work product privilege, attorney-client information, and instruct the witness not to answer any information that would reveal attorney-client communications and or work product.
Mr. Moore, you just testified he's not working on the case. Mark Poe's not working on the case.
I think you need to do a little research on what work product communication is and what attorney-client communication is, Mr. Tyler.
Well, I think
we stand on our objection.
I think I know better than you, quite frankly, but I'd like to just have an understanding of the basis of your objection. He's not doing anything.
Objection is stated on the record.
Stated on the record. All right, this is going to be a fun motion, right? Did Mark provide you materials about me, Mr. Kinney, at any point?
Again, I'm going to object on the grounds of work product communication, work product privilege, and attorney-client communication.
Will you take your attorney's advice? Robert?
Yes.
Did you ever supply the Western District of Texas with any materials about me, Robert Tyler?
Objection vague.
I don't know what you mean.
Well, according to the judge's recent ruling, the judge said that the Western District Admissions Committee received a copy of the court's December 18th order. Was it you or someone you know who supplied the Western District Committee with that information?
I've never said anything to the Western District Committee.
That's not really the question. I'll ask again. Did you know that someone was providing the Western District of Texas admissions committee with the court's December 18th order.
You mean the public order that was issued December 18th, in which
Yeah,
the court
that's
issued a
one.
show cause asking you to explain your behavior?
Correct.
That order was all over Austin. I did not submit it to any committee.
Did you know of someone who did?
No,
So you never knew that communications were taking place between third parties and the Western District of Texas Admissions Committee? Is that your testimony?
I don't know what that means.
Okay. What part? Do you know what knowledge means? Do you know what knowing something means?
Of course I know what that means.
Okay. Did you know that a third party was providing materials? Materials could be anything, like a document, a letter, an email, to the Western District Admissions Committee.
Objection vague.
I don't know what you mean by a third party. I did not know.
You know that I, based on your counsel, Raymond Mort III's suggestion, applied for admission to the Western District of Texas around September of 2020. Do you remember that?
I remember you telling us that you had applied, yes.
Did you know about any communications that were sent to the Western District of Texas regarding my admission?
Oh,
Objection
yes.
vague.
Yes. What were they?
Public orders from the California courts in which you were sanctioned or threatened with sanction. They were sent to the admissions clerk by myself, acting as an attorney. And in order to fulfill my duty that I believe I owe to the bar to make sure the court is fully informed.
Wow, that's a rich one. Go ahead. So you think you're also the defendant in this case, right? So do you think you'd be an advantage if I wasn't Evan's lawyer?
I'm sorry, can you say that one more time? So do you think you would be?
Mr. Kinney, do you believe that you'd be at a tactical advantage if I was no longer representing Mr. Jowers?
I don't know what that means.
You don't know what a tactical advantage is?
Could mean any number of things. It's too vague for me to answer.
Do you know what it means in litigation? You wrote about it in your opposition to the motion to disqualify, so you do know what it means.
Objection argumentative.
What was your answer, Robert?
I do not know what you were referring to.
You don't know what a tactical advantage in litigation is? You know what a tactical advantage in litigation is?
I have a general idea of that general term.
Do you believe that you would have a tactical advantage if Robert Towler no longer represented Evan Jowers in this case?
To the contrary, I think Evan would have an advantage.
Well, how so?
Perhaps he'd find a less argumentative lawyer who does different sort of style of work and focuses on his case rather than his own situation. But
Other than that, any other reasons you believe you'd have a tactical advantage if I wasn't in the case?
I didn't say that I would have a tactical advantage if you were not in the case.
You'd say Evan would have a tactical advantage if I wasn't in the case.
Perhaps.
And that the only reason you provided order from California that you obtained from Mark Poe was because of your duty to the bar. Is that your testimony?
That's a compound question.
Objection.
It's a compound question, and I don't agree with many of the premises. So if you'd like to split them out and
Is your testimony that the only reason you provided information to the committee because of your duties to the bar?
Objection mistakes evidence.
that was not my testimony.
All right, so why did you do it then?
Objection mistakes the testimony.
You can answer.
Why did I do what?
Why did you submit materials to the Western District of Texas Admissions Committee regarding
I did not submit anything to an admissions committee. I do not know who is on the admissions committee, and I did not address anything to an admissions committee.
You sent it to the secretary, you said, or the clerk, correct?
There is an admissions clerk at the United States District Court in Austin. I consulted with the admissions clerk, and she suggested that if I had information that might be useful regarding an applicant, I could send it to her for further activity. I do not know what she did after I submitted the public orders, which I did not obtain from Mr. Poe. I obtained them from public records, and I don't know what happened with them afterward.
Why did you provide those materials to the clerk of the admissions office for the Western District of Texas?
Why? Well, because she suggested that if I had information that could be useful in the deliberations regarding whether someone should be admitted as a full member of the bar of the court, I should send that to her, and she would determine by consultation with the court what should happen with those things.
Why did you initially make contact with her?
Oh, because of your presence in the case as a pro hoc vice attorney who, in our judgment, was misbehaving, creating considerable additional work and unnecessary work for everyone involved.
You told the clerk for admissions that I was creating too much work for you?
That's not what I said.
Okay. So you called the clerk for the admissions to complain about me?
No, that's not what I said either.
Did you go in person? Was this over email? Was it over telephone, or was it in person?
I've already said what I did.
The initial meeting you have not said.
What meeting are you referring to?
The initial contact you had with the clerk for the admissions office.
I told you I called the clerk on the telephone.
Okay. So that on that initial call, you complained about me, correct?
No.
You told her that I was misbehaving, is what you said.
No, that's not what I said.
Okay. What did you tell her about me on that first call?
Nothing.
So she picks up the phone. Hello, clerk of the admissions office. How may I help you? What do you say next, Robert?
I don't recall the conversation.
So you don't know why you called her?
I've already told you I called to figure out what to do in order to submit information that the committee or whoever determines admissions to the court might find useful. If the information that I submitted was useful, they used it. If any applicant had orders like that were public and that applicant had already submitted those with his or her application, I presume those would not be useful. I do not know what the admissions clerk did with those documents. Perhaps you had already submitted all these orders, etc., in which case she would have found no use for them. But I can't recall if I even mentioned your name in the conversation.
Well, the documents would have my name on them, right? The orders.
You were asking me about the conversation.
Sure, but I don't think there's any dispute that the materials you provided have my name on them, right?
Well, there were orders from various courts in which you were being sanctioned, et cetera, for your activities in those cases. And of course, they had your name on them.
And you obtained those from Mark Poe, correct?
No, they were public records. I got them.
And what service did you use to obtain those records?
I don't remember.
Do you have a Westlaw account?
I do not have a Westlaw account.
So how did you obtain these without a Westlaw account?
I don't remember specifically how I obtained them, but there are numerous ways to get things that are public records other than with a Westlaw account.
All right, what's like one way?
Google.
Okay, so for example, the tentative ruling in the Valerio matter, how did you get that?
I don't know what you're referring to.
Well, there was a tentative ruling on a discovery matter in a lawsuit called dubbed Tyler Smith versus Joseph Valerio, CTLR. And you obtained a tentative ruling that you submitted in one of your filings. How did you get that?
I don't remember, and I don't remember that ruling specifically.
Okay. So when you did submit these various rulings that you claim I was sanctioned in, did you provide those to the Western District Clerk for admissions to influence their decision-making process?
No, I submitted them as a member of the bar in good standing who had knowledge of things that I thought might be useful to the persons determining whether someone should be admitted to the bar of the court. What happened with those things, I have no idea.
In other words, you believe that looking at these materials might impact their assessment of my candidacy. Correct?
I certainly knew it was possible that those materials could impact your candidacy, but I also was aware of the requirements of the application form that any such materials be submitted by the person applying for admission to the court. And I assumed that they would already have them. I just wanted to be sure.
Mr. Toller, are you suggesting you withheld those documents from the court?
Mr. Mort, don't be cute, all right?
I'm just asking the question. You're acting as though Mr. Kinney gave them something they didn't already have. Is that true?
I'm not the one being deposed, so I ain't gonna answer.
Oh, okay. I think we know the answer to that.
I think you.
So let's waste another hour and a half why Mr. Kinney gave the documents you withheld to the court.
I think you might know the answer too, which is why you're in trouble. Now,
not in trouble at all. It sounds like you withheld material information to the court.
Raymond
Thanks
Mort
for making that clear.
Hey, you don't know how much trouble you're in.